Morning, guys. Here from Sunnyside Lead. So we are starting to move into this program now. People are registering. The LPC has published a notice where they're going to have an informative webinar to explain this whole process to you. Also, everybody is working together. So that's it. James Clark here, advocate, High Supreme Court. By now you ought to be used to seeing my face in this program. So yes, let's start. Now the thing we're going to be doing this morning, very quickly, we're going to be doing 3 recordings. And the first recording we're going to do in the drafting of legal opinion. First I'm going to tell you how I do it. And then we're going to go through a little source document that has been loaded for you so that you can see and have it at your availability. Now, just to tell you how legal opinions is a very big part of my practice, very big part. And I actually make a very good income out of it. A lot of complicated cases that comes my way. People start in first with a legal opinion. For example, last year, during the COVID lockdown, I was asked to draft a legal opinion for a case down in Cape Town on attempted murder and corruption within the SAPS, the investigating officer having allegedly taken bribes, etc., etc., being in collusion with the prosecutor, even maybe the magistrate. And after I received the instruction, I set up a legal opinion that was almost 160 pages long. And I'm going to tell you now how I do it. And then you have to develop your own way. And we'll also look at what this guide is saying to us in terms of how they advise it. We all have our own way. To make a long story short, is we won that case. Because the moment in the team, the moment my legal opinion was released into the team, everybody reads it and everybody studies this. And then they decide, the attorney down in Cape Town, he was an old magistrate that was taking this case on. The accused himself that had lost hope because of what have happened to them, maliciously transferred from Cape Town to Pretoria Central Jail before you could get him out. They lost hope. After having been in this unjustified situation for almost 2-3 years, lost a very well-known restaurant there. I don't want to mention the name or the town. And when everybody read a legal opinion and they saw all the cases that's been cited from the DPP and the National Prosecution Authority, the NPA, then that was when the decision was taken that this is a good case, this is a solid case, this case is merits, the law is on our side, the case precedent is on our side, and we won it. That's important. And after we won it, the gratitude of these people that was illegally prosecuted was much more worth than the payment. Much more worth. So this, because they always fought this, but never, they had advocates before, they had attorneys before, but it seems that something went wrong there. And they knew that such an unjustified action cannot be legal. There must be something in the law. And there was a lot. There was a lot. Another opinion I drafted many years ago that comes to mind was a rape case. And it went to the Supreme Court of Appeal. That opinion I wrote there was over 360 pages long. So you get opinions that's 5 pages long, you get opinions that's 20 pages long, and it depends on a case you're involved with. If a legal opinion comes to me, unfortunately, it's very long. All right, guys, how do I do opinion? First of all, I fear my instructor. I have a fear of the instructing attorney that asked me to set up an opinion. I'll tell you why. You get his phone calls, you get his quick email to say you have to set up a legal opinion. And what happens then is you start working with it. Later you send it out. People are not satisfied with it. And they said they asked you this and that and that. And that you didn't follow instructions. I've had it before. And you learn. You'll see when you go into practice. You very quickly learn the hard way. And one of the places where you learn the hard way the most is not getting paid as an advocate. No, we don't want to pay you. You didn't do what we asked you. this bogus excuses. And there's two ways you can deal with that. You can change your tactics and make circle, you bind them to paying you, or you can get upset and storm in there, and whatever happens, happens. And I was an old military guy, so I do have a temper if I'm acted towards the unjustified by people I least expected. And the tongue is a powerful tool. It's landed me in trouble before. So put a guard in front of that if you're a counsel. We all get upset in the public arena too. So that happens. So what I always do is if somebody phones me and asks me for a legal opinion, I say I will not do it until you have briefed me in detail in terms of what you want. So that's very important. Are you listening to what I'm saying, guys? You must brief me in detail. And you must brief me in writing, not over the phone. Now, the moment that brief comes in, or maybe it's in the form of an email, the first, in my legal opinion document, the first thing I do is I copy and paste that instruction within that brief or within that email into my legal opinion. I would write instructions from instructing attorney so and so and so, and then of course my heading would say case so and so versus so and so, whatever the situation is, and I paste and copied it in italics and put abbreviations. This is what you told me to do, and this is what I'm going to do. Nothing less. Well, maybe more. In last year's case, the attempted murder case, after studying the facts, I set up a 160-page legal opinion that brought him to winning the case. I did not stick to the instructions of that was given to me. After studying the case, I see that I had to do much more because I saw so much more. And I saw how we could win it after I've studied the facts and the merits and all of it and the case law and the legislation. So I did more, but you can never do less. I went over the top. And I still said to the instructing attorney, you guys must put it up for consideration for me to pay me more. And they won it on the more. And of course, they never paid. And it doesn't bother me because I accepted the instruction as is. But I don't think it would have been in the interest of justice for me as an advocate not to go where I went after I saw what I saw. So I'm teaching you something now. As an advocate, and I did make the phone call. I did say to the instructor, listen, I'm going to have to do more. And they say, well, I don't think they can pay you. And I say, I don't have a choice. Whether they pay me or not, you can ask. And maybe they pay me in 10 years' time. I don't know. It doesn't matter. The gratitude, the thanks that came back after they were vindicated was more than enough. So the first thing I'm teaching you to do, streetwise, is copy and paste your instruction into the beginning of your legal opinion. It also helps you to go back the whole time and see that you are meeting the minimum requirements. And you can decide where to go from that. That's the first thing I do. And very interestingly, the second thing I do is my second division is documents. So first one is instructions received. Second one is documents received. Every document I have received, I build in there. And many times as I receive documents, I see the stuff outstanding and I ask more. When they are sent through to me, I type it in there. So how do I type it in? I take the document, the email, all the documents I receive physically or electronically, it doesn't matter. I always print my stuff, unfortunately. I'm killing trees still, but I'm an old dinosaur. So what happens here is I type email from so to so, dated so and so. This kind of contract, dated this and this. Every single document I receive, I built into my documents division. Because just 2-3 weeks ago, I was told by another person that instruction was given to another advocate that came later back and rendered the opinion. The opinion wasn't sufficient, didn't meet the requirements. And this guy said, now that advocate is saying I didn't give him everything, but I did give him everything. So what I do is document every document you send to me. It doesn't matter how I receive it. And sometimes that's long. And it's cumbersome, but I do that. That's my second division. So let's have a look now. Practical teaching from an advocate on the street. Instructions word for word. I don't even change the spelling mistakes there. Just like that. Then the documents received. Then number 3, I summarize the third division I go in for my own sake, is I in short summarize the facts of the case, the important factors. They've told me, then I summarize the case, the facts, and then I can see, well, I've now summarized the facts, but something doesn't make sense. Then I phone, I reach out, I say, listen, I just need to ask a few questions, a couple of things I don't understand, I don't see here, I think it should be here, or what happened there. I get all the information. I do not proceed. I do not proceed. I do not proceed without having summarized the facts to the point where I'm satisfied as an experienced advocate. Now, this is what I need to work with. And I'm very careful to go any further. Because if there's some facts I don't have, I can go in the wrong direction in going and doing my legal research or whatever I need to do to get this going. So that's how I do it. I summarize the facts. I phone until I'm satisfied. I have summarized all the available facts and I really don't have any more questions on it. So what do we have? We have the instructions received, documents received, summarization of the facts. Then the first thing is the first division I moved into, headings, everything, legislation, pertaining and relevant legislation. Then I start working the legislation. I look at the facts and I pull all the legislation that's relevant to the case and I build it in. I look at all the acts. I go everywhere. Not court cases, legislation, the law. I go and look at the common law, I look at statute, whatever you call it, ordinances. It doesn't matter. I find everything I can find, all right? And then when I'm finished there, I have another heading, case precedents. Case precedents is then the court cases linked to the facts and the legislation. They come together in court cases. And then I go and look for the best court cases post-1996, as far as possible, not always possible, but it's preferable. And I get a biggest, the best cases there on the foundation of stare decisis, and I build them in. I build them in there. And then when I'm finished with that, now let's stop. Let's see. I have taken my instructions, I've pasted it in. I've noted all the documents I have received. I've now found all the law and I've put all the law in there. I'm already on a lot of pages now. This legal opinion is long. I found all the court cases in terms of stare decisis, preferably after 1996, pertaining to the facts and the legislation. And now, after I've done that, then I go and look at the facts and I apply the facts to the court cases. I apply the facts to the legislation. Then I say, all right, in terms of what has happened here, that goes under this act, there and there. This court case says this judge ruled that, and I bring the legislation department and the court case department together, where I apply the department of the facts, the summary of the facts to the case. And that can go on for a while because I'm one of those guys that take my time. I'm one of those guys that want to go into detail. I mean, 160 pages is a long opinion. Now, when I'm finished there, then I end off with making a recommendation. And then I talk about a success rate and I talk about those kinds of things. And then, of course, my heading, my legal opinion has got my Chambers Advocate, Dr. Advocate James Clark heading. And, of course, at the bottom, Advocate James Clark. And then, of course, my footnotes has got all my credentials in there, my qualifications. That is how I do a legal opinion. All right, let's look at it again. Streetwise, on the street, real advocate, not academica. Right, what do? I get my instructions, copy and paste. I don't even change spelling there. Just like that. If you're going to attack me later on, we're going to go back there. Then all the documents I've received, every single one, it doesn't matter if it doesn't seem unique, everything is typed in there. Then a summarization of the facts after I'm satisfied, and I have phoned 1,000 times making certain I'm happy, I have all the facts. Then I find all the law pertaining to the situation. Then I find all the court cases pertaining to the situation. Then I bring the facts, the law, and all the court cases together in what I usually call commentary. I open up a commentary division and I start bringing them together and putting them together. And then lastly, I have recommendation. And I talk about a success rate and I talk about what we should do, how we should do it, what kind of application we must bring, what kind of plea we must bring. Or I talk also about further investigation, because we work a lot with private investigators, a lot. You will not believe that most of these cases come to me through private investigators that knows I'm an advocate that acts in this manner when I receive an instruction. So then they will phone the attorney of record and say, use that guy. We know about him. He's well known, and when you get something from them, it's going to tell you something. So they are the recommendations. They go and they talk about it, and we need more. Then I say we need to know this, and then and that's how I do it. So that's me. That's how I do a legal opinion. And as an advocate, that's become a very big part of my service delivery in terms of earning an income. And people know if they give me something. Then, of course, because I'm cumbersome, I go into detail. I'm also not the cheapest guy under the sun. I've been an advocate for a while. I've paid my dues. I've done my walking around the courts, falling over the building, rubble, and whatever. And you get paid for your seniority. And this is how I do it. And I tremendously enjoy it. When I get an instruction like that, I close up my chambers, I close the doors, you cannot see me. And I will maybe open in a day just for 1 or 2 hourly slots. But then I'm closed down. And the front desk personnel and the other personnel in my chamber, no, you leave him alone. He's going to be in a bad mood if you bugger around with him. He's in a good mood while he's doing this, just taking coffee, something to eat now and again, so he doesn't die and forget to eat or drink something. Because if you work, you forget. I'm like that. I totally forget. And that's how that operates. Okay, guys? That's how I do it. Now, I'm going to talk to you out of the Lead Opinion Writing Practical Vocational Training Guide. I just want to see if they tell us here who wrote it. Ah, yes. It was Judge Hussein. And I thought it was him. Let's quickly go through this and see what he says. All right. And what is that? Yeah, there he starts off on page 1. He says, good advice is always certain to be ignored, but there's no reason not to give it. Now, I have written a lot of legal opinions. I like what he's saying there. And he's quoting Agatha Christie. Okay, well, we dinosaurs, we all know who Agatha Christie is. You might not know, except if you studied at the university a little bit about him. But in many legal opinions, I have said no. There's no prospect of success here. Let's rather try and make a deal. So you have to go there sometimes also. So you got to remember, it's not your job in a legal opinion to win the case. That's nice if you can do it, and I love doing that. But every now and again, it's dead in the water. And through years of experience, I have developed the sixth sense to find the loopholes. I'm good with identifying the law and the gaps, and we can get through that narrow opening. But there has been cases where there's no way. There's just no way. And then that legal opinion will show them. And then I will advise how we must rather move to a settlement or sit down with the MPA or the prosecutor and say, okay, well, is there another way we can do it? And so on. All right. So that's what he says there, Agatha Christie. So, but there's no reason not to give it, especially if you're getting paid for it. Am I right? Eh? All right, guys, then introduction. Just quickly, the purpose of this man is to enable you to draft a basic legal opinion. Opinion writing is very much part of a lawyer's work. And at some time in your career, you will be called upon to present a legal opinion. I do it a lot. This might even become part of your daily work as a lawyer, and that's where I am. Every now and again, I get one. And I love it. I really love it to dive into the facts. You know, that investigator, blood in you. I was a captain in the police service years ago, so I really enjoy this kind of stuff. This manual will help you acquire the basic skills you will need to get there. All right, let's see. What is the first skill? Judge Hussein says, the most important basic skill required is the ability to write well. You must be able to express yourself in writing in such a manner that your reader understands a point easily. I'm going to talk about that now. In other words, we do not want to write like a lawyer. All right. I have a habit as an advocate, and I still come out of the old school. I love my Latin. Whoa, I love my Latin. Really, guys, you must take it serious. There's terminologies that they'll throw you at court, and then when you say you stand in a group and experienced guys are talking and they quote a Latin and you say, yeah, you're lying, you don't know what's meeting, you're just smiling. Get it under the knee. Make certain that in all the guides, go look at all the guys, usually at the glossaries at the back, the most well-known Latins that's used in court, we use there. And if you're going to use Latin, if you're going to go in that road of a legal opinion, or the drafting of a contract, then you must build the interpretation division in also, because your client's not going to know what you're talking about. The problem is, here's the problem, your court cases, there they throw it, left, right, and center. So you have to deal with it. So yes, when I get to the law, the court cases, and the facts and the commentary, I'm rendering on that, and I move into the recommendation division, then you can see from top to bottom how my language changed, because now I'm talking to real people. Remember, even in the commentary, with the law, the court cases, and the facts. I'm talking to an instructing attorney. He understands me. But the moment I go into recommendation, I make it very basic. This is the situation. This is what I'm running. This is my conclusions. You can even have a conclusion division in. I sometimes build it in there. You have conclusion, and then you go to recommendation. A lot of times I do that too. I break it up if I see it's going to be too much. So language is imperative. You can stick with the lawyer and the advocacy language there at the top because it's a legal jargon after years. It's amazing. It's a different language we talk. And then, of course, at the end, you have to bring it home. You have to bring it home. I remember when my dad, last year's legal opinion was received, it was about 2 days. They needed 2-3 days to read it. And then they came back and they were so happy. And they went back to court and it was all a success story for him. Locked up for 2 to 3 years. Unjustified, because our IO is corrupt. Investigating officer and IO. Nee. Right, let's go on. They say that's the first skill. Then they say also there, what is regard to today's plain language? I'm not going to take that further. This is going to be a very short clip. You don't have to worry about tea and coffee. Even this guide is only a couple of pages long. This is legal writing. You've got to find your way. The big thing is, if you have passed your LLB degree and you're doing the vocational training, you're doing assignments with us, don't worry about it. You'll pick up the language. You'll pick up the language. All right. Writing techniques there on page 1 still. Let's have a quick look. What do they talk about there? What do they say about writing technique? You can hear my voice. I'm excited about this stuff, aren't I? Because I love doing this. Oh, if I just can impart on you, you must love what you are doing. So many of my colleagues are grumpy. You see them called hanging. Why are you hanging? Scott again today. I'm excited. I walk in there and I'm always excited about what I'm doing. That is the foundation of your success. If you're grumpy, how can you be successful? That energy cannot be positive energy. So just something there. You got to love what you are doing. And you guys are going to become advocates now. You must already love that idea. Love what we are doing here. If you look at all these things, I don't want to do this. It's so much work. You're in trouble. Being an advocate is a lot of work, a lot of reading, a lot of drafting, hours and hours, 3 o'clock in the morning. Otherwise, you've picked wrong. It's hard work. But in my life, it's been extremely rewarding. I'm very happy I did this. I'm very happy. All right. Let's quickly look at the techniques. Paragraph 4. Before this is on your e-learning platform, this small document. Before we go to the opinion itself, consider the following writing techniques. I'm just going to run them through quickly. I've got 3 clips I'm making for you today. Today is, of course, for me, the 4th of the 6th. Whenever you see it. So again, good morning, good afternoon, good evening, depending on when you are looking at this. Ensure that you express yourself concisely and coherently. Yes. Say what you have to say and no more. You will succeed in this by being relevant. Avoid excessively long sentences. That's not always possible, but yes. Use the active rather than a passive voice as far as possible. The court held rather than it was held by the court. The plaintiff brought a claim rather than a claim was brought by the plaintiff. I'm Afrikaans, so these things usually with me is troublesome. But in my chambers, I've got them English ladies there that works for me. And I always throw it out and say, read it, which is a big problem for them because then I want it immediately and it's 360 pages long, you know. So, but they chase it through the system. I'm Afrikaans, so I look at English differently. If you are Xhosa or you're Zulu or you're in one of the other languages, maybe you're Portuguese, I don't know, German, then you look at English in a different way. So it's important what I'm saying here. We must always try and do it the right way. You can even hear when I talk over these recordings sometimes. I have not swallowed the Oxford Dictionary on English, so yeah, that happens a lot. Avoid stock phrases and stale ticks. Overuse it clearly, obviously, and of course. If the matter was really that obvious, it's unlikely that I would have been the subject of a legal opinion. Cliches, generalization, excessive use of jargon. Avoid contractions like use it is instead of cannot instead of can't, informal language, slang, and humor. Yeah, I'll never use humor on a legal opinion. Whoever asking you for a legal opinion is in trouble. I'll never use humor there. Most of the time, they don't even see me. If I put off the legal opinion for an attorney that's going to do the case himself, then they don't even meet me. So they don't know who I am, what my intentions are behind the way in the manner in which I'm saying things. So we've got to be careful of that. Your writing can be simple, easy to understand without having the pompous. You do not have to use big words and complex sentences construction. Sometimes I'm pompous against the opposition. When I call them out, when I find stuff in that legal opinion, say, look at this is pompous. What were they thinking? I would say that because that would show the person that's going to act, or myself if I'm going to be the advocate in court, or about the way I want to argue that in court. It's pompous. What were they crazy? All right. Avoid upsetting or angering your audience with racist, sexist, and gendered language, of course. Gendered language can easily be avoided by gender neutral description by using she and he or his or her. All right. We're living in the new world. We're living in Section 9 of the chapter in the Constitution, the Bill of Rights, in terms of equality. Don't worry, guys. You're also going to be able to say these things out of here. It's the Section 9, Chapter 2. I know it's there. It's visible going on in 95, 96. We know that. We know that. You're going to get it. It's not being clever. It's just experience. Don't worry about it. People always think we're so clever, but it's through experience that you pick it up. You work every day with it. Obviously, somewhere along the line, you're going to be able to recite it out of your mind. Lead with your main idea. Most of the facts will have a core idea. Most of the problems will have a core idea. But I always, in my opinion, have sub-ideas running beside them. So your main objective is to solve the core idea. And then as you are solving the core idea, you talk about the side ideas. Lead with your main idea is good. That's attacking it first, but you'll see it branches out. And I also write internationally religious books, so I understand what happens when you write about a core idea, but every now and again you deviate, you branch out. I always used to compare it with the Amazon River. That's my core idea. But anybody that knows the Amazon River will know there's millions of sideways. You go literally off for kilometers. And that brings you back into the core idea again. It brings you back. Always remember in your legal opinion to bring yourself back. As a general rule, state a main idea of a paragraph in a per sentence. The topic sentence always introduce what you're doing in this division, in these paragraphs. And I'm all about chronological. You've got to be chronological. We are not chaos, we're not anarchy, we order. So I understand that in that division where I bring the law, the court cases and the facts together, then there I'm very chronological. I know that in the conclusion and the recommendation divisions, if I have to, chronological, so that they can follow it. It's not jumping around. The same with drafting of contracts. Do not keep your readers guessing. As a lawyer, you want to tell your reader what your point is up front before you develop the details. I don't do that. I don't do that. If you have listened to the way I put a legal opinion up, you'll see I begin there, I go here, I go there, then I'm here busy finding the facts myself, then I go there, and in the end, I tell him what I see, never in the beginning. Because I tell you now, I've done it once or twice, and I always have to go back and fix it, because it changes. But if I chronological work myself out, here in the end, you can always skip. With me, you can always skip the whole thing before reading it in depth and go into look at the conclusion and recommendation, you know precisely what's going on. But everybody's got his own way, so that's their way. I just cannot do it. I found it to be, for me, a problem. Vary the length of your sentence in general. Use short sentences to emphasize ideas. Use longer sentences. What I do is I usually break them up in dots. I don't like to use commas. I go dots. I like to put things under each other. I like spaces. I like neatness. That's why I have people in my chambers. I throw it out today. No, they've got instructions. I only work in Arial font 10 spacing 1.5. That is my criteria within my chambers, and through the years, the people working for me knows this is how it works. You give him something else, you're going to get into trouble. Put keywords and ideas at the beginning or end of the sentence. Do not bury a main point. You never bury a main point, obviously. Agree with that, because that's the thing. That's the crux of the case. That's bringing it home. At university, you learn the legal principles. Now you have to apply those principles to the benefit of your client, so do that. The quality of your opinion will depend on the substantive content, namely the evidence, the facts, logic, and legal principles. Logic. The way I set it out is logical for me. And I have never had a client come back. I have clients come back and say, well, thank you very much. It's like a storybook. We totally understand what you're doing. You're starting there. So we know what we or our attorneys has told you to do. We can see these documents, by the way, we've got more, we're sending through to you. We can see you didn't have everything. Is this going to change your mind? Give us a secondary opinion on the extra documents. We can see what you did. We can see the law. We didn't see the laws mixed up with court cases. We can see the law, then we can see the court cases, and then we can see how I bring it together, and at the end, either in one division or two divisions, a conclusion, recommendation, we can see where you're going. Logic is very important for me, but we all have our own way. This is how they are doing, and mine is basically 95% like this. Just a few changes there. We all have our own way, right? And we want to teach you, but I like to teach streetwise. Empowering with knowledge, falling over the rubble in court. That's what I teach. I teach practicality. Been there, done it. So this is how it works. Just put an academica, the theory aside a little bit. The substance of the message and the style of presentation together determine its persuasiveness. The two go in hand. Okay, I hear what they're saying and I agree, but I'm not there to persuade anybody. My legal opinion is never persuasive. Has never been persuasive, will never be persuasive. I take the facts, I take the law, I take the court cases, I put it together, and I give him the logical opinion derived out of there on a legal platform and a case precedent platform. I don't like the word persuasive. I'm not there to persuade them they have a case. I recommend to see you for a case, but based on this, based on the above, there and there, this is not persuasive. This is a fact. And of course, you're at the mercy of the court at the end of the day. So I know what I mean. Not attacking it, but I don't approach mine with that. All right. Then there on page 3, consider the techniques you want to use. They say know your audience. Let's have a look at that. The first rule of legal writing is to know your audience. Who are you communicating your thoughts to? Are you directing your document to a judge or a magistrate? Is this for a high court, a constitutional court, lay client or CEO of a multinational? It really doesn't matter when I do it, because the latter part of my legal opinion talks to the layperson always. There in the beginning, law, court cases, even presented the facts. That's a little bit tricky. But there where we get to the latter part, I'm always on the layperson side. So even if you read it from beginning to the end, somewhere along the line, you're going to totally understand what I'm doing. So that's the way I deal with that. Even to a magistrate, I don't care. My end result will always be in plain language, and a layperson will be able to understand, hey, this is what this guy is saying. We get it. Context before detail. Always tell the reader what to expect. Put context before detail. Tell the reader what your case is about and set out your most important points up front. You do this by framing material issues at the outset. The idea is to first state a context before you start with the details. You do not want the reader to start guessing, becoming confused, or deciding to make up their own minds. All right, you can read that. I've told you how I'm doing it. It doesn't totally fit into that. Frame the issues, be brief. Framing the main issue is vital. Remember, we all have our own way. I know precisely what they're saying there. I used to do it like that in the beginning. I've formed my own way. So you can decide in which direction you want to go, not attacking that. If it works for him, it works for him. If it doesn't work for me, it doesn't work for me. There's no benefit in stating the details of your case if the reader knows nothing about your case. Give your reader a roadmap or a heads up. My roadmap and heads up, that's very important. I agree with that. That is there where I summarize the facts. That's it. That's it. Frame the issues, be brief. Framing the main issues is vital. This is what happens in opinions, pleadings, the heads of arguments. It's important to state what the issues, disputes are, and what a conclusion you will come to. My heads and arguments and my legal opinions are very different. My heads and arguments are concise, they're short to the point, and they do their job. My legal opinions is cumbersome. I explain everything thoroughly. I am not concise. I am never concise. I've read opinions that's concise and they're good. That's not me. I take my time walking that road through the facts, through the court cases, facts upstairs, law, go down, look at it. I'm one of those long, endearing drafters. Stating the facts. Once you have framed the issues, your task is now to state the supporting facts. Yes, very important, immensely important. There will be supporting facts. You have to go into that. The facts must be stated concisely in a chronological sequence. Yeah, the idea is not to make your reader do the work. You have to do work in drafting your document. You have to come to the conclusions you come to. Use headings. I love headings. Don't you love headings? Don't you love a decent draft? If I put up a particulars of claim founding affidavit, there's hearings, man, there's stuff going on. If I put up a contract, there's stuff going on. I just heard I've got a contract coming in now worth 32 million rand to sell a movable property, and they want me to make certain it's correct. You know, when you sell immovable property, first of all, there's a lot of stuff happening. If it's over 5 million rand, there's curves there. So very excited about it. The structure, I heard it's coming my way. And already I know I'm going to change this. I know it. I know it. I know this is not going to be as neat as I like to do my stuff. And there's also a reason why they're sending to me. They've done it, sending contracts to me before. So obviously they like what we're doing. Neatness, headings, clarity, chronological. Write short paragraphs. That's not always possible, but absolutely preferable. But when you get my legal opinion, that might be problematic. Some of my paragraphs are long. And if my paragraphs are long, I like to use short sentences in them and not too many commas. The whole thing about a long paragraph is you go on and on. But if you have enough full stops in a paragraph, you won't have a problem. But preferably short paragraphs. But when we deal with law, I mean, if I put up something for 160 pages, which was so complicated, sometimes that is difficult. Let's look at a drafting principle they're talking about here. I want you to use the following drafting techniques. It will show in the quality of your opinion. Use clear and precise language, yes. Use plain English words absolutely at the end, yes. Avoid unnecessary words always. Avoid inappropriate words always. Avoid synonym strings and doubling. Lawyers are notorious for doing this. Agreed and declared. Okay, yes, there's a couple of stuff I like doing. It comes out of the old school. I love it still. Use verbs, not nouns. Sure. Draft in the present tense. Yes, okay. Avoid the word shall. Use must or will. Yes. Use an active over as a passive voice. Use active over a passive voice. All right. Use appropriate punctuation. I hate it when that's not correct. I agree. Use short sentence, simple sentence structure. Not a problem. It's not always possible, but great. Use paragraphs and sub-paragraphs. Absolutely. You can take those big paragraphs and break them up. Totally agree. Use headings. It's a must. Always define a term and use it throughout a document. Built-in interpretation division if you have to. I agree. Observe a strict time sequence. It's easier to follow where facts are set down the chronological sequence. Oh, is that what he meant? Almost misunderstood what I'm saying here. Yes, I agree now. Avoid lengthy quotations. Make the point in your own words. Avoid lengthy quotations. It's not always possible. A quotation is a quotation. You cannot muck around with it. So if you're going to cut something away which will take away from the point you're trying to make, you cannot do it. So I understand what he's saying, but it's not always possible. Do not be tempted by copy and paste technology. Be very careful of that. If you're going to copy and paste, make double certain that you read it at least twice. Years ago, I set up a contract for a big client of mine. Phones back. He said, "Who's this guy?" So no, I don't know. He says in your contract. It was a clause I pasted over. I needed here. We laughed about it. We were pals. But he taught me a lesson. He taught me a lesson. Copy and paste is very dangerous. We do that, but you must be really. You got to read it twice and make certain what's going on there. But now be careful. You cannot change spelling and stuff in court cases. When I work with court cases, I don't change anything in a court case. Right? That's also something I want to bring under your attention. If the judge made a spelling error, I leave it like that. I don't muck around with it. Especially if it's a court order on top of that. Above all, keep it short. Lengthy documents are not persuasive. Mine is extremely long. I've never had a complaint. A long-winded document is bound to lose the attention of the reader. You can decide yourself there. Brevity improves the clarity of the message you want to convey. You can decide yourself there. A well-drafted legal opinion covers all relevant possibilities, but should not go further. All relevant possibilities. All relevant possibilities. That's me. I don't miss a beat. I sit and think about it. 2 o'clock in the morning, I wake up and I think, yes, I didn't build that in. So I got to do that tomorrow. When you become an advocate, most probably you're going to become like this. 2, 3 o'clock in the morning is when I wake up and suddenly realize stuff. Don't ask me how that works. I don't know. But all relevant possibilities. So you'll never get a short opinion from me. Traditional legal documents are often clogged with clauses attempting to cover every possible contingency, no matter how unlikely. I never broach unlikely. I totally agree here. For the sake of making money, for the sake of charging more, building a lot of nonsense into the document, you can be up for misconduct under the Code of Conduct. And remember, we experienced litigators, we see it immediately. Say, what's he doing here? What's he doing here? This is 4 hours of work he didn't have to bill for. And there's case precedent on that. There's case precedent on that. People get into trouble over that nonsense. Apply your mind in cosmetic matters, okay? A well-drafted document should incorporate for thoughtful use of white space, paragraph, readable typeface, bolds or italics for emphasis instead of capitals. I always use bold and italics. I totally agree. I like my documents to be super neat. Right. The next thing we're going to talk about now is paragraphing. Let's just talk about it quickly and see what I say and see if it's in line with what we did say. You are required to write your opinion using numbered paragraphs. I don't always do that. I don't always do it. It has enormous benefit, but I number my headings. And then under it, I've got individual paragraphs. But the benefit of numbering your paragraphs is that people can refer to it. People can refer to it. So yes, I'm not going to walk away from that. I do it, but I don't always do it. I like telling my story and it's flowing. But numbering your paragraph is actually what legal people do. So I'm not going to walk away from. This is something I don't always do. I am going to teach you now. Rather do it. Yes, I'm going to agree here because I do see the benefits. I don't always do it, but maybe I should start thinking about it now that I'm reading it again here. It's a requirement of model legal drafting that the document must contain numbered paragraphs. That's what I'm saying. So you can do that. All right. So I'm teaching you also to do that. It's a benefit rather than anything else. The basic layout. All right. Now I've explained my layout to you. Let's see what they do. Generally, when writing opinions, we use what is commonly called the Virac method. This is what we were taught, by the way, in the bars. So this is practice. But as you are practicing, you develop your own skills. Virac stands for facts, issues, rule, argument, and conclusion. Facts, what happens around, great. Issues, here you are expected to identify issues, okay. Rule, identify the legal rule that governs that issue, list the elements of each rule, list any relevant expectation to the rule, list any relevant case names and statutes if applicable. And then I go to argument, justify your views with reference to the facts and the law. Conclusion, directly answer your question you were required to deal with, and so on. So if you take mine and you look at their headings and you kind of merge them, I'm about 95% there. I think I just have a little bit of extras in there because I mitigate risk towards my own liability. That's why I start like I start. Why? I've learned my lesson. You got to be streetwise. But yes, it's basically the same. No problem there. Agree with everything. When writing your opinion, you will use the Virac method and have 4 main parts to your opinion. They are first part. The first rule is always to commence by opinion by setting out the facts. Not even going to read further. Remember, I do my instruction first, my documents, and then I do the summary of the facts. So we're great. We're good there. What does they say in second part? The first rule is always to commence the opinion by setting out the facts as if you've been all right. Second part, here set out a question that your client has posed for you. Now, that is in my instructions I've quoted in the beginning, because there's the question. They're instructing me to do that. So even if they instruct me, it encompasses, encapsulating a question. Third party, here set out the recent answer to those questions, law, court cases, the facts. So I arrived there eventually. Fourth part, here you provide the summary statement of your conclusions, and I totally agree with that. You can go and read the rest in your own time. So we're there. I'd say 90-95% I'm there. I might just have another approach and have more in there. Research techniques and analysis. This can be time-consuming, stepping in and writing an opinion. If this is not carried out efficiently, the whole exercise might turn out to be a loss in terms of hours spent and fees that can be charged. Guys, this is so important. Some people get a legal opinion and they see the money coming, but they're not really in the mood to do it, and they don't want to sit for hours and hours and days. And then they just look at court cases and read a paragraph here and there and they muck it up. You have to read all the court cases. Your legal research and a legal opinion has to be 100% correct. You cannot have a blowback. It can cause you damage, if you know what I mean. There are 2 basic steps in carrying out essential research. Firstly, you must obtain and carry out the analysis of the fact. That's what I do in the summary. And secondly, must carry out the analysis of the law, and that's what I do in 1, 2, and apply it in 3, below the first 2. So that is what you have to do. Very excellently set out here. I really appreciate what the judge has done here. The facts, as an attorney, you'll be responsible for obtaining a mandate. Don't work without a mandate, and paste that mandate like I do into the beginning. Your client is not expected to come with a well-formulated question or questions. They're more likely to bring a document to explain their problem in consultation. All right. When my mandate is not clear, I don't work. I go back and I say, I don't understand stuff in the mandate. They say, no, that means that means better. So I send me a new email. So I totally agree. Get a new mandate. It makes sense that the mandate is clear. I have received mandates that just doesn't make sense, and I'm not going to do it. You're going to have to send me a better mandate than that. You don't have to be rude about it. You phone and say, listen, guys, come on. Useful technique, fact analyzing is the following. Only consider facts that are relevant to the issue, obviously. Ask if client can provide proof of the relevant facts. Most of the times when I write a legal opinion, I ask permission of the attorney while CCing the whole time. But then directly to the client to ask information, doesn't have to return and then get to me. He's not always in his office, but he gets CC'd every time. I don't like working directly with clients. Only accept clients' versions of any disputed fact if version is probable. If you do not accept client version, it simply means that a judge will also reject it. I ask the tough questions of my clients. The attorneys knows it. When I walk in the boardroom, they've already prepared a client. This advocate could be here. This guy is going to ask you the tough questions. It's better you tell him the truth. All right? And it's very important I say that to you. That's one of the qualities I'm known by. I walk in and ask you in your face the tough questions. If I think you're lying to me, I tell you, I think you're lying to me. That doesn't sound probable. Come on, man. What's going on here? I'm your advocate. We're on the privilege here. I want to know. I don't want to get ambushed in court. I really ask the tough questions. And I urge you to do the same because it's embarrassing. When I was a junior advocate, once or twice I was caught like this. Judge saying for the bench for me, come on. Come on, look at the opposition's documents. I'm like, sure, all right, what do I say now? No, I ask the tough questions. Make a note of the undisputed facts. Then test if your client's version of the disputed fact is probable, all right? If you have to make findings of a fact, ensure the finding that you make is probable in relation to the circumstances of the case. Well, you most certainly cannot come with a finding that's not related to the problem at hand. And it's a valid point. I've seen people do it. That's why the judge is putting it in here. People are in a hurry. They don't want to do it. They just want the money. You're not applying your mind. You don't want to work hard. You're lazy. You're lazy. And then this happens. It can be supported by credible evidence. If you look at how I'm doing, this is why this is so important. That's why I'm doing it in the manner I'm doing. Summary of the facts, law, court cases, bring them together in the commentary, and then recommendation or conclusion or recommendation, and then last conclusion. By the way, conclusion to a document means it's the end. So be careful with putting a recommendation on the conclusion, although you can, because that conclusion can be the conclusion to your findings. All right, just be careful how you structure that. If you have to make findings of a fact, then there it can pass the test of is that likely to have happened. All right. Okay, then I talk further there about the law. Let's quickly have a look at that. Only after you are satisfied that you know the facts, consider the law. Depending on the questions, the law may be found as follows. Now, that is so true. I'll tell you why. The summary of my facts, I urge them. I ask questions before I go to the law. Because if the summary is not correct, or it doesn't have all the components it should be having, or they're not telling me anything, I might not pull all the relevant law. So you go to textbooks, journals, academic writings, absolutely. Articles and newsletters, I love the Rebus articles. Statutes, including regulations and directives, especially court practice directives, if it's one of those legal opinions on rules and procedures, you do get them also. Law reports are paramount, and foreign law reports can also be used. And I have bolded that also in because the Constitution allows it, right? Consult the leading textbooks, commentaries, and reports of the arena, say, unless you are conducting historical research or there are special reasons for doing this, do not consult old edition of textbooks. Let me give you a trick. I always look at dates of court cases, articles, post-1996. Post-1996. And even then I'm cautious. Here around 2004, 2003, then I'm satisfied because our democracy, our new constitution, democracy came into being after 1995, 1996. Do you understand now? So I'm very, very careful to use old stuff, except if the old stuff is still relevant in terms of our constitution. So that's important, guys. That's very important to me. All right, and then they, as the law stated, at the date of the publication, look at that. All right, that's on page 9. It actually talks about all the pointers ahead, so I'm not going to go further with that. Let's go to page 11 on paragraph 43. The quality of your opinion will be determined by two aspects. Firstly, its substantive content, and secondly, the matter in which it is presented. The substantive content of your opinion is based on facts, logic, legal principle. The presentation based on the skill as a writer, setting out your reasoning in a matter that is easy to understand, presenting your work in a user-friendly format. That is so important. That latter part of my legal opinion is always user-friendly form, because I know now the client, the layperson is going to read it. I've set my thing up there, and now I need to make certain that they understand it. Number 44, there is a process of reasoning that applies when you begin to find answers to the questions posed in your mandate. The first thing to remember, the conclusions of fact you rely on must be supported by the evidence before you, and the conclusion of law you come to must be supported by your findings of fact. All right. All right, now they talk about the division, they say, composing the opinion. So we're going to actually look at that first and second parts again. The first part is factual, according to them. You can go through that, and the second part is the issues. So we've already spoken about it before here, and I've told you how I do it, so you can go read that yourself. Remember, I'm not lecturing to you. This is self-evaluation. This audio clip has been made available at my request to you, so that you can look at it and get a little bit of streetwise on it. And then they end off on page 13 with some sensible advice. Let's have a look at that. It is simply not possible to be a successful lawyer in the absence of good, indeed excellent literary skills. You cannot write anything, let alone opinions, without sound literary skills. I agree. You cannot attend a course to improve these skills. They are acquired through your proper application and desire for excellent. Well, you can go on English courses. You can go and do advanced courses in language. But I understand what he's saying. So in that sense, I agree. If you worry that you, and by, of course, he's totally right. Now, I have acquired some of my legal jargon in terms of English through experience. If you worry that your literacy and analytical skills not up to par, never fear. They can be developed with time. You can go through that. I agree with that. He says that one way to start is to read more books. That is true. Those of you who are serious about a career in the legal profession, commit yourself to reading one book a month. That is one book in terms of legal aspects, so you can get hold of that. And that is then again Senior Counsel Advocate Ismail Hussein. He was a judge in here. He was a judge, although I still refer to him as a judge out of respect. And what do I think about his opinion writing? I think it's a very, very good guide. All right, it has what you need to get you to where you're going. All right, guys, give me a second here to think. I've said that to you. I've said that to you. That's basically the foundation of a legal opinion. Oh, the last thing. I have an advocacy letterhead, and I've seen other advocacies letterheads. Now, my legal opinion runs on my letterhead right through into how many hundred pages. And guys, take care in your letterhead. Take pride in your letterhead, because that's also where you impress people. Put your information up there. I have, since I started out as an advocate, I've got a little kind of blockish logo there. That's been with me for years. I've a certain way my letterhead looks, and I've been commended in the past. But I have seen co-counsel's letterheads that's bland. Nothing is going on. There's no creativity there. So that's the last thing I'm going to say in terms of legal opinion writing, because that front page for me is always very important. My qualifications and there in the footnotes is there. Most of it is there, telling people you cannot make your footnotes too long also. That does not have a benefit. But the bare essentials to show people that I've given this guy this job, that's his qualifications. My practice number is at the top, all of those things. So people can phone and say, hey, this is the practice number. Did he pay his fees? Is he legally entitled to do this work? My address, my email address, everything is there in the letterhead. My name is big there. And then, of course, I sign off. I paste my signature in. But if you are going to listen to advanced contracts that I did yesterday, as today's the 4th, that was the 3rd for you. The day before that, we did electronic signatures, and that qualifies. So, guys, on this first clip for this morning, I want to make to you on drafting of legal opinion. That's it. All right, thanks for joining. Thanks for looking. And I hope this has helped you. Now, remember, it's a good source of income. Market yourself. Say to the attorneys of records and your clients, please, guys, I do legal opinions, and started writing legal opinions. Now, listen to what I'm saying. You will not believe how I've learned out of drafting legal opinions. Newest court cases I was suddenly reading. Amendments to Act, law I knew nothing about, and then I went and studied it. So legal opinion for every legal practitioner, especially an advocate, is imperative to his gaining experience widely in all types of legislation and within the legal practice in general. So this is why this is also important to me. All right, guys, I'm going to push this button now. That's going to stop this recording. I'm out of here, and good luck. Good luck. I'm rooting for you. And let me go on to the next one. So the next clip, you'll see me, and I think the next clip I'm putting up, you might not find it like that, but I think the next clip I'm going to talk about is customary law. Exciting, eh? See you later.